Good morning, everybody. Welcome to this webinar on a Monday morning. This webinar is going to contain the highlights from our all-day construction conference that we had on the 3rd of October, just recently. I'm going to be speaking on the impact of the Grenfell Tower Inquiry final report. Hannah Fry will be looking at recent trends in insolvency and construction. Patrick Hennessey will be looking at delay and disruption developments. And David Sawtell will be speaking on adjudication guidance, recent cases. So, my name is Kate Grange. I was one of the lead counsel on the Grenfell Tower Inquiry. And I'm just going to start sharing some slides with you on that topic. And the topics I'm going to cover this morning are basically some key findings from the final report of the inquiry that was published on the 4th of September this year, potential implications of the findings for construction litigation, some important criticisms of the testing regime in relation to external wall performance and the potential impact of that, and key recommendations that the inquiry's made and the potential impact of those on the construction industry. So the final report at phase 2 built on the phase 1 report, which had been published on the 30th of October 2019. That first report examined what happened during the course of the events on the 14th of June 2017. And this second report built on that and asked an essential question: how was it possible in 21st century London for a reinforced concrete building, itself structurally impervious to fire, to be turned into a death trap? And the first substantive section of the report is called The Path to the Disaster, and it looks very closely at the role of government and other related bodies in the 30 years running up to the Grenfell Tower fire. And the report concludes that the fire was the culmination of decades of failure by central government and other bodies in positions of responsibility in the industry to look carefully into the danger of incorporating combustible materials into the external walls of high-rise residential buildings and to act on the information available to them. And in terms of the findings, the inquiry concluded that prior to the fire in 2017, the government was well aware of the risks posed by the use of combustible cladding panels and insulation, but failed to take action. In particular, failed to heed warnings from other fires, both home and abroad, particularly those involving external cladding and insulation. And that the government was well aware that some of the guidance in approved document B, in particular, and specifically the Class 0 requirement in relation to external walls, was an inappropriate standard to be determining the suitability of those walls. The inquiry concluded that the government knew that approved document B was unclear but failed to take the necessary steps to remedy that. There were also findings about the deregulatory agenda that the government had pursued, and that had been dominated to the detriment of matters affecting life safety. It's also interesting to note that bodies close to government, advising government, also come into for some criticism. The BRE in particular was said to hold a trusted position within the industry and was recognised nationally and internationally as a leader in fire safety. However, the inquiry concluded that from 1991, much of the work that it carried out in relation to the testing of fire safety of external walls was marred by unprofessional conduct, inadequate practices, and a lack of effective oversight, together with a lack of scientific rigour. So it was those advising government as well as government itself who also come in for criticism. There was then a key focus on the manufacturers of the combustible cladding and insulation materials. And here the inquiry reached some important, strong findings. It concluded that there had been systematic dishonesty on the part of those who had made and sold the cladding panels, that in particular 3 organisations had engaged in deliberate and sustained strategies in relation to the testing processes, misrepresentation of data and misleading of the market. And that was, the inquiry looked at 3 particular companies, Arconic, Celotex and Kingspan, when it reached those findings. And it also found that those strategies succeeded partly because the certification bodies, principally the BBA and the LABC, failed to ensure that statements in the product certificates were accurate and properly based on test evidence. So there's some very significant findings made about manufacturers, which I'll come back to. The inquiry also looked in detail at the refurbishment of Grenfell Tower that took place between 2012 and 2016. And all of the professionals involved in that refurbishment come under significant criticism. I've set out some of the key criticisms here. The architect, fire engineer, principal contractor all come under criticism. For example, failing to recognise that the ACMPE was dangerous and warn against its use. That was something that rested with the architect. The fire engineer failed to meet the standards of a reasonably competent fire engineer and failed to produce a final version of an important document, which is a fire safety strategy for any building. And the principal contractor, that was Ryden in this case, also displayed an inadequate and casual attitude to fire safety, and in particular didn't coordinate the team properly, didn't ensure that it and its subcontractors understood their responsibilities, and in particular who design responsibility rested with. There was also criticism of the cladding subcontractor and also of the client. Importantly, for those advising clients, the inquiry concluded that the TMO itself had failed to take sufficient care in its choice of architect and paid insufficient attention to matters affecting life safety. And in particular, that surrounded the work of the fire engineer on the fire safety strategy. There were also significant criticisms of building control, failing to properly scrutinise the design or choice of materials or satisfy itself that the design would comply with the building regulations. So all of those professionals come in for some significant criticisms. So what are the potential implications for construction and litigation? I'm just going to highlight just a few this morning. It seems to us that the findings are likely to be of particular relevance in any claims against building professionals and manufacturers. The detailed findings that you see about the individual professionals involved in the refurbishment are going to be quite important, I think, in terms of explaining what the standard of reasonable care and skill is in such cases, and what the duties are that are owed by the architect, the main contractor, the fire engineer in similar cases. There's also going to be a crossover in terms of fitness for habitation, where we've got breach of the building regulations relevant to fire safety. A lot of the findings about, for example, defective cavity barriers potentially have impact in terms of that standard of fitness for habitation that we'll see in Defective Premises Act claims. The obvious other inevitable attention is going to now fall on manufacturers because of the very significant findings that have been made by the inquiry about the manufacturers. And this is likely to extend not just to the manufacturers that were considered in the report, but I would suggest to many other manufacturers. And I think people will be looking very closely at their materials and their representations they were making in their marketing materials. There are various routes by which manufacturers may end up being brought into litigation, for example, over the remediation of buildings and where developers are seeking to recoup their costs. Sections 148 and 149 of the Building Safety Act provide claims, new claims and causes of action against manufacturers, although they require a legal and equitable interest in the building to bring such claims. And so people may be looking to other sources or other ways in which they can use those causes of action. The obvious route is contribution claims under the 1978 Act. There may be also more kind of traditional common law claims in terms of misrepresentation or collateral contract, there may also be assignments of the 148, 149 rights from those with legal and equitable interest over to others. And potentially some pressure to reform the Building Safety Act to allow perhaps developers to have more direct claims against manufacturers. The inquiry makes some very important findings in chapter 111 about assessing the fire performance of external walls. And I would advise anybody who is advising on external wall matters and has to look at the testing regime to read this chapter in some detail, because it contains quite important findings about the testing regime and has clear implications for the way that external walls are assessed in the future. The stay put strategy is absolutely key to that. There's no hard recommendation to change the stay put strategy in the report, but there are very strong pointers about the significance of having such a strategy. And in particular, the inquiry says that in a building with a stay put strategy, no significant spread of fire beyond the compartment of origin can be tolerated, and that in a stay put strategy, it will only be acceptable if there's a negligible risk of fire escaping into and spreading through the external walls. There's also significant criticism of the fire testing regime. Now, some of this is historic criticism, but some of this is going to be of relevance to testing that we are still using at the moment. The inquiry concluded that there had been an over-reliance on small-scale tests, which did not provide relevant information, and that even the large-scale testing, the BS 8414 testing, where there was then BR 135 classification, the inquiry concluded that that testing had limited relevance because there was a lack of correlation between the functional requirement to adequately resist the spread of fire and what happened in that test. And in particular, you could have a test that passed that and yet was still not compatible with the functional requirement, particularly if there was a stay put strategy. The inquiry concluded that you've got limited relevant test data from that large scale test, that some materials don't reach their peak temperatures until much later than tested. So the test lasts 15 minutes or the first phase lasts 15 minutes, whereas some materials like HPL don't reach their peak temperatures until 30 minutes. The inquiry concluded that that test tells you what's a bad idea to include in an external wall, not what is a good idea. And the inquiry was also critical of some of the European testing and a lack of test evidence supporting the efficacy of cavity barriers. So important findings in that chapter, which do have the potential to impact on 8414 testing and BR 135 classifications where they are relied on, and I know that they are being relied on as we speak in relation to tall buildings. It has obvious implications for the past 9980 guidance, given the extent to which that guidance still relies upon BS 8414 testing. There's scope potentially for more buildings requiring remedial work if the inquiry's findings on testing are looked at seriously. And this all comes back to the need for a holistic assessment by a fire engineer. There are other potential implications of the report. Possibly we might see more of a focus on building control now, and whether there's scope for revisiting that responsibility, perhaps where there's been an assumption of responsibility in particular cases, and also, given the criticisms of government, maybe renewed focus on that. I'm just briefly going to highlight recommendations, and then I'm going to pass on to my colleagues. The report makes findings under 4 headings, including under the construction industry, and although the inquiry says that the premise that the Building Safety Act is a step in the right direction is right, the inquiry suggests that the government should go further, and the big recommendation is a new construction regulator responsible for a number of different functions, including those I've got on the screen, and including responsible for new initiatives which the inquiries recommended, such as the licensing of contractors to work on high-risk buildings, and the accreditation of fire risk assessors. So there are some important recommendations which have the potential to have huge impacts on the construction industry. The government's taken 6 months to decide what to do about that, and only time will tell as to what happens. So that's the end of my presentation. I'm going to hand over to Hannah Fry now for her presentation on insolvency.
Thank you very much, Kate, and good morning, everyone. Thank you for joining us. I'm just going to share my slides now. I'm going to be taking you through a whistle-stop tour of recent trends in insolvency and construction. So first, statistics of insolvencies involving construction. As reported by the Insolvency Service, in July of this year, the number of registered company insolvencies was 2,191. So it was 7% lower than in June, but notably it's 16% higher than the same month in the previous year. So all types of company insolvency were higher in July 2024 than in July 2023. The number of company insolvencies remains much higher than those seen during both the COVID-19 pandemic and between 2014 and 2019. However, interestingly, it remains lower than the peak of the 2008-2009 recession. But the reason for this is that the number of companies on the effective register has more than doubled over this period. And in terms of insolvencies in the construction industry specifically, and you can see this on the slide that I'm sharing, the construction industries experience the highest number of insolvencies of any sector in England and Wales, with 4,303 company insolvencies reported this year, accounting for 17% of all company insolvencies. Now, it's typical for the construction sector to have the highest number, but it is notably higher than previous years. So in the year to June 2024, the total number of construction firms becoming insolvent was 4,690. That's a 2.1% increase on last year, but it's 53.3% increase on June 2020. So we're now seeing sort of post-COVID and the relief that the government was giving being lifted, more companies going into insolvency, specifically in the construction sector. And in terms of high-profile cases, you'll probably be familiar that ISG, the 6th largest construction firm in the UK by turnover, and who holds more than 1 billion worth of government contracts, entered into administration last month on the 20th of September. And this echoes the downfall of Carillion in January 2018. So insolvency and construction is a particularly relevant topic at the moment. Looking at the outlook for construction companies big and small, and you can see the summary of the BCIS construction industry forecast on the slide. So looking at the next 5 years, it's predicted that building costs will increase by 15%, while tender prices will rise by 19% over the same period. Overall output is expected to fall by 5.5% in 2024 compared with last year. And this decline is mainly a result of decreased output in the housing, private, commercial and industrial sectors. But long-term growth is expected to return in 2025, with a total new work output increasing by 20% by 2029. So long-term, it's more optimistic. Now, just turning to the warning signs of insolvency to be aware of. And generally the broader industry picture, which I've just gone through, you should be borne in mind, but you want to be thinking about, are there delayed payments? Are there renegotiation of terms, early invoicing, frequent change of suppliers, or deteriorating service performance? One or several of these factors could be pointing towards typical signs of insolvency coming. Now, in terms of tools to manage risks and challenges, and to take this briefly, first, due diligence. So we recommend that when commercial parties are undertaking their contractual relationships, that the risks of insolvency and potential warnings are considered before entering into the contractual relationship. Second, that contractual rights are considered. So it's important for commercial parties to carefully negotiate, review, and understand the contractual rights and obligations upon insolvency of another contracting party. And in particular, third, termination. Commercial parties should be familiar with their termination rights under the construction contract. If you want to terminate a contract, a party should check the termination rights under the contract to ensure the events are expressly provided for and are captured by the termination clause. Otherwise, a party runs the risk of wrongfully terminating the contract and could be presented with a counterclaim for repudiation. It's also important to bear in mind the Corporate and Insolvency Governance Act from 2020, which came into force on the 26th of June 2020. In essence, Section 14 of that Act introduces a new Section 233B into the Insolvency Act. This prevents suppliers to contracts for the supply of goods and services, such as contractors and subcontractors, from terminating the contract or supply on the grounds of a customer, such as an employer or a contractor, becoming subject to a relevant insolvency procedure. So this is something to bear in mind. Now, just turning to insolvency and contractual rights in construction contracts, and considering the amendments in the new JCT 2024 edition, the definition of insolvency in clause 8.1 has been amended to reflect the wording of SEGA, which I've just taken you through. This introduces two new restructuring and insolvency procedures that are designed to assist in rescuing financially distressed companies. So first, the statutory moratorium process, known as the Part A1 moratorium. This is intended to provide financially distressed companies with a short breathing space of at least 20 business days from enforcement action by certain types of creditors. And secondly, the restructuring plan procedure under Part 26A, and this is often proposed by a financially distressed company and then validated by a court order under Part 26A of the Companies Act. So what is the practical effect of these amendments for employers and contractors? So these two new clauses provide additional grounds for termination for both the employer and the contractor. So one would think that the right to terminate on such grounds seems to contradict the purpose of SEGA, but ultimately, if you think from an employer perspective, these amendments will provide welcome additional protection, allowing a greater spectrum of pre-insolvency processes to trigger a termination right. And this is particularly relevant in the context of the statistics that I've taken you through. Interestingly, the updated drafting doesn't address Section 233B of SEGA, which prevents the contractor from immediately terminating or suspending the performance of its obligations upon the employer's insolvency. And as a result, it's unhelpfully left unclear as to whether a contractor has the right to terminate in an employer insolvency situation. That perhaps might be more rare, but can happen. So in light of this, parties may want to consider enhanced termination rights independent of insolvency. For example, the right to terminate for non-payment, a right to terminate if upstream contracts terminated, and/or a right to terminate for convenience. Alternatively, contractors may request that an employer provides security for its payment obligations, such as a retention bond or parent company guarantee. I think another recent trend that we're going to see is, whilst all of these construction companies then go into insolvency and maybe liquidation in particular, once the liquidators take over, the possible claims that could happen post-insolvency and the risk to directors should be considered. So some of the common causes against directors post-insolvency that we've seen are Section 212, which is the breach of director duty provision known as misfeasance, fraudulent trading under Section 213, wrongful trading under 214, transactions at undervalue under 238 and preferences under 239, and ultimately director disqualification. And I think it will be interesting in the next couple of years to see how these claims have progressed, in particular against directors of construction companies. And last but not least, we can't finish the section without a case law update. So I'm going to very quickly take you through the case of Peabody Trust v National Housing Building Council. This is a judgment of Andrew Mitchell KC, sitting as a Deputy High Court Judge in the TCC from August of this year. And it provides valuable judicial guidance around the timing of an insured's cause of action under an NHBC Build Mark Choice policy, providing cover for contractor insolvency before practical completion arises. Now, the key issue that the court had to decide is whether there was a limitation defence to proceedings under an insurance policy, and this could only be decided by considering the language of that policy. So option 1 of the policy provided insolvency cover before practical completion, and it stipulated that this section applies if you lose the amount provided paid to the contractor in accordance with the building contract, or critically, have to pay more to complete the building of the home because the contractor is insolvent. So both parties agreed that this option was relevant because the original contractor went into administration in June 2016. An alternative contractor completed the works, and then practical completion was achieved in January 2021. But the parties disagreed when the claimant's cause of action accrued. So NHBC argued that it was the date of the original contractor's administration, where Peabody argued that you need to look at the meaning of have to pay more to complete the building of the home, which meant after practical completion when the final costs were known. So the judge agreed with the latter with Peabody and dismissed NHBC's summary judgment application. Time was held that it didn't start running until it didn't start running on the contractor's insolvency in June 2016, but at a time that was to be determined at trial when the claimant had to pay more to complete the units as a result of that insolvency. So practically, I think the key takeaway from this case is that although the wording of insurance policies and limitation clauses will be different and are not blanket across all contracts, this case remains helpful guidance on when such a cause of action will accrue, and that the starting point is that limitation is not wholly tied to the date of the contractor's insolvency, but rather the financial outcome that follows. So that will be helpful when looking at cases of a similar nature. Thank you very much. I'm now going to hand over to our next speaker.
Good morning, everybody. I'm Patrick Hennessey. I'm going to be speaking briefly for you on the topic of delay and disruption. And I'm going to try and just share the slides with you now. One second. Sorry, I'm just trying to find which of the screens to share with you. If you just give me 1 second with that. Share. It should be this one. Okay, so hopefully now everyone will be able to see that slideshow, and I can. Always the difficulty of trying to do this from home rather than Chambers. Apologies, everyone. Okay, so I'm hoping now that everyone should be able to see in front of them the delay and disruption slides with obviously today's date and my name. We had a very useful panel in the afternoon session of the whole day conference looking at trends in delay and disruption claims, and particularly looking at liquidated damages clauses and limitations of liability caps. And there were three relevant, relatively recent authorities, which we looked at on that panel. Well, three key ones. Triple Point Technology and PTT, which was the 2021 UK Supreme Court decision. And then we had a look at Drax Energy and Wipro and Tata Consultancy Services and Disclosure, which applied some of the principles that emerged and tested some of those points. I'm going to look briefly at Triple Point Technology first, and then we'll see how some of the principles that emerged from that applied to Drax and Tata, which were the following and more recent examples. So let's start with Triple Point, and I don't know how many people will be able to recall Triple Point. It was a fairly significant decision in the Supreme Court in 2021. The background was a software contract in a number of the recent development cases concerning liquidated damages and limitation of liability caps. We see that it's not pure construction contracts, but also contracts for the provision of software program platforms, and that was the case here. It was actually a commodities trading platform that PTT, a Thai state oil company, had commissioned to be installed and managed and sort of run by Triple Point. One of the reasons why this case gained, I think it was fair to say, a certain amount of notoriety, if that's the right word, amongst the legal community, is that it had a kind of fairly unusual journey from first instance through the Court of Appeal up to the Supreme Court. The first instance decision adopting the TCC adopted what one might call an orthodox position with regards to liquidated damages accrual, in the sense that one of the issues in the case was, did liquidated damages accrue up to the point of termination of the contract, which I think would be the normal understanding. First instance in the TCC, that was held to be the case, but perhaps where this went on an unexpected direction is in the Court of Appeal, where the Court of Appeal found on appeal against that decision that actually liquidated damages had not accrued in respect of a number of works done, and that was a difficult position to reconcile with the orthodoxy and indeed with the contract terms. So the Supreme Court judgment was welcome in that provided clarity both on the liquidated damages aspect and on a limitation of liability aspect. In respect of the liquidated damages position, it was the orthodoxy that was kind of restored, if that's the right word. The Supreme Court was unanimous in rejecting the Court of Appeal's judgment, which has come to a contrary interpretation, and found that unless the parties provide otherwise by clear terms in their agreement, liquidated damages will accrue and be payable if the agreed event for which they are payable occurs before termination. And the emphasis was on commercial reality. The fundamental commercial purpose of a liquidated damages clause was relevant to its construction, and it was Lady Arden in her legal judgment who said at paragraph 35, parties agree a liquidated damages clause so as to provide a remedy that is predictable and certain for a particular event. Here, as often, that event is a delay in completion. The employer does not then have to quantify its loss, which may be difficult and time-consuming for it to do so. So I think particular and certain, I mean, obviously we wouldn't necessarily be discussing cases concerning disputes over delay and disruption clauses and liquidated damages clauses if we were always as clear and certain as that. But I think that was a welcome and clear signal. And then in respect of whether the limitation of liability clause, again, the emphasis was on the requirement of a full textual and contextual analysis, in this case, in considering liability cap provisions. And again, the clear words would be needed to restrict valuable rights. And Lord Leggatt in particular looked at this aspect and had some interesting considerations, noting that the modern view was that commercial parties are free to make their own bargains and allocate risk as they think fit, and the task of the court is to interpret words used fairly, applying the ordinary methods of contractual interpretation. So having had a brief period of uncertainty from 2021, we see the UK Supreme Court laying down some clear guidelines on how to approach liquidated damages clauses and limitation of liability clauses. And we can see that applied, and indeed with express reference to Lord Leggatt's analysis last year in Drax Energy Solutions and Wipro. Now again, Drax and Wipro was a master services agreement under an IT contract, and I've put up on the slide there the relevant clause which came under dispute. There was these disputes make, as I'm sure everyone will be aware, an intense practical difference. The difference between the analysis of the claimant and the defendant in triple point was, effectively, was there a claim worth £1 million or £14 million? So it's by an order of magnitude. And again, what we can see in Drax and Wipro is that there's a substantial effect on whether it was the case that there were multiple caps as claimed by Drax, or a single aggregate cap as claimed by Wipro, and when the claims arose and when they were capped by. So we're looking at, as you can see from the left-hand side of that table there, some 32, 40, nearly over £60 million worth of claim on one analysis by Drax, but by Wipro saying that no, this is actually capped in this way. So one of the notable features in Drax and Wipro was that when considering the competing contentions of the parties, the court had regard firstly to a case which we didn't specifically discuss during the conference, but it's probably worth making a note of, which is Royal Devon and Exeter NH Trust and ATOS. That was 2017 England Wales Court of Appeal Civ 2196. And that was a case which looked at aggregate liabilities on the multiple caps. But then also Drax specifically, Mr. Justice Waxman looked at what he called, he labelled the triple point considerations. So he looked at Lord Leggatt's analysis from triple point, the 2021 Supreme Court case we were considering at first, and applied what he considered, what he called these triple point considerations. So he looked at what Lord Leggatt had said, and he looked at that, and he said one has to be realistic. If, as Drax alleged, the project was proving or threatening to be a disaster within the first year, it was hardly likely to commission further work, and indeed at some point it would have terminated. But that's of course what Drax did in 2019. I do not think that the arguments raised by Drax show that Wipro's interpretation makes no business sense or was commercially absurd or anything like that. In particular, you know, that Mr. Justice Waxman didn't think that the disparity between the cap in Drax and Wipro and the effect of the cap in triple point was the same. He didn't think that it was unrealistic for there to be a difference, commercially unrealistic to be a difference between those claims, even though on the table, as you can see, they're quite stark. And he didn't apply the triple point consideration, or didn't consider the triple point consideration to carry much weight on his interpretation in Drax and Wipro. So commercial reality can cut both ways, but it's interesting to note that even applying those same principles, what one judge thought in Drax and Wipro didn't necessarily confirm with what the Supreme Court had thought about the effect of a cap in triple points. If there are practical lessons to be taken away from Drax and Wipro, my colleagues on the panel were emphasising that it's always going to be in the words. So clear attention has to be paid to the words of the clauses that are being put in. I'm going to pop back up on the slide. That is not the most clearly drafted necessarily of provisions. And I think giving real thought to the consistency, the internal consistency between liquidated damages clauses, delay and disruption provisions, liability caps. That is necessary. It was noted that the clauses, the contractual provisions in Drax and Wipro had some sort of linguistic quirks. And that should be compared to the drafting provisions in the Devon case that I also referred to, where the interpretation that was preferred was the least bizarre. So I think the real takeaway here, and that what came out of the triple point, is the need to give clear attention to try and make sure that the terms used are consistent and clear internally and make sense externally. And that also came out finally in case earlier this year, Tata Consultancy Services and Bearing. And again, this was an IT contract, very similar issues to the issues in dispute in the other two cases that we've looked at. Was the cap on Tata Consultancy's limited liability, did it apply to each of an individual counterclaim, or was it single aggregate that applied to all claims under the contract, and how was that limited? And again, the provisions in question were said to be far from a model of clarity. So once again, it is a problem of the language, the consistency of the language, and how that can be applied with commercial common sense to all the possible permutations. And I think, again, if there's a takeaway for us as lawyers when we're looking at drafting in these provisions or putting together these agreements, it's trying to think through the ramifications of possible outcomes that these clauses will be applied to. Key takeaways: negotiate these things at the outset, understanding those practical implications, considering all of the options and defining the terms. And I recommend if you have the time, have a go back, read through Tata Consultancy Services Limited, because it's a very good practical demonstration of how some of those issues come out and how you can apply them, or how you can aim off so that they don't occur with your own contracts. And then I'll hand over to my colleague, David, who I think is going to wrap us up today with an adjudication update. Thank you.
Thank you very much, Patrick. If you wouldn't mind handing over the screen, that's brilliant. I'm going to be talking about adjudication. And for many of us in the UK construction industry, adjudication is the only show in town. And since it was incepted through the Housing Grants Construction and Regeneration Act 1996 as a mandatory requirement for construction contracts that fall into the criteria in the Act, it often is the only form of dispute resolution that parties resort to. But in the last few years, and in the next few cases we'll be discussing, we can see there is a tension between adjudication and a number of other regimes, such as insolvency, and Hannah's really touched upon that. It also touches upon contractual regimes as to conclusiveness, but also when it stands by itself. When you have a case where the adjudicator's decision has been superseded, then what happens to the adjudicator's fees? So we're looking at all of those in the next few minutes. But first of all, I'm going to start with a case about something which has been manifesting itself in a number of construction cases I've been involved in, is what is the status of counsel's advice? Quite often, one is asked to produce an advice for purpose of referral or response, to say either how absolutely brilliant the claim is, or I'm so dreadfully sorry, but the claim is simply misconceived. And counsel's advice is often deployed for that purpose. And what Henry's Construction Projects Limited against Promet Limited decides is what are the status of counsel's advice. And this is what Mrs. Justice Jefford had to wrestle with in this case. And this was a case about a CVA. So Promet had gone into creditors a voluntary agreement, and then subsequently it brought an adjudication, said that Henry was in repudiatory breach of contract and Promet had accepted it, but claimed payment for work done and damages. Henry counterclaimed, but ProMep argued that this counterclaim was itself settled by the CVA. So there's going to be a clear point of law for the adjudicator to wrestle with, and that was, what did the CVA do to the cross claims? Now, ProMep didn't produce an advice, it produced a summary of an advice from counsel they had obtained and put it into its rejoinder and said that it supported its position. The adjudicator decided in ProMep's favour that Henry had repudiated the contract and ProMep was entitled to be paid at £90,000. And we saw two different proceedings begin. Part 8 proceedings to decide whether or not the CVA settled all claims, and then Part 7 proceedings to enforce the adjudicator's decision. And the question was this, whether or not there was a misrepresentation of fact as to counsel's advice. Because when the actual advice was obtained, it was unsurprisingly expressed in far less trenchant terms than the summary of the advice had been produced before the adjudicator. Now, the courts, the only way that would actually insist in terms of adjudication enforcement is if there was an arguable defence the decision was procured by fraud. But the key point was this, counsel's advice wasn't evidence, so certainly couldn't be fraudulent evidence. The summary, in fact, was not so outrageous as to be a fraudulent representation of that advice. And I think a key point as well is that Henry could have raised this issue as to the summary, as whether or not it was clear or represented counsel's advice, and could have done that in the adjudication. And that itself is often a key point when it comes to an argument as to whether or not you have produce some fraud which could vitiate the decision. So whether or not there's a misrepresentation of the advice or ProRep's understanding of it, it simply wasn't material. And just to take two key points, first of all, counsel's advice is only a persuasive technique. It's a legal argument. And though wouldn't completely close the door as to whether or not an opinion could be so badly misrepresented it could amount to fraud, but it's extremely difficult to envision what those might be. So the next case I'm going to look at is to do with conclusive evidence provisions. And these are often adopted in construction and indeed in other forms of contract to close the door on arguments about a dispute. If you don't raise a dispute in time, then that's it. You're out of time and you have a conclusive evidence about that dispute which you can't go behind. And just to be bang up to date, here's an extract from the JCT Design and Build 2024 contract, which has a form of wording which is spookily similar to ones which you'll see in 2016 and 2011 editions as well. And indeed, you can trace this a long way back. And you can see similar forms in indeed the NEC forms of contract as well. So it says, as from the due date for a final payment, the final statement shall, except as provided for in Clause 1.8.2, have effect in any proceedings under or arising in connection with this contract as conclusive evidence. So if 1.8.1 is engaged, it's conclusive evidence of a number of different points. 1.8.2, however, is saves the day. 1.8.2 says the effects on the relevant statement specified in clauses 1.8.1, 4, 24, 6 shall be suspended pending the conclusion of any adjudication, arbitration, or other proceedings, and shall be subject to the terms of any decision, award, judgment, and any assessment of those proceedings, where those proceedings are commenced before or within 28 days after the due date for the final payment. So you can see you either have to have proceedings on foot or you need to start them within 28 days of the due date for the final payment. Otherwise, clause 1.8.1 is going to engage. The policy behind this has been set out in a number of cases since at least the 1970s. And is Mr. Justice Colson's terms, which as he then was, which I shall probably highlight. It gives limits to uncertainties and the expense of arbitration and litigation. It stops cumbersome and painstaking inquiries to prove outstanding or running accounts, and provides agreed limits to the scope of disputes. But the countervailing policy comes in the Gilbert Ash case, which is that you don't typically tend to contract out of your disputes and your common law rights unless you really want to. You need clear wording for that. And indeed, you've heard Patrick's discussion of Triple Point and PTT Public Company Limited earlier today. That was again emphasised. You really have to be clear we're going to contract out of running a dispute. So there's a tension in the case law between the need for certainty, but also a policy factor that parties don't tend to opt out of their common law rights. And this came into play in a case arising out of the Battersea development, Battersea Project Phase 2 Development Company Limited against QFS. So, a design and build 2011 contract, you get a notice of adjudication on foot, and then you have a final payment notice issued. Now, parties by this point actually engage in 3 adjudications at once, so they agree the referral can be served by the 13th of January 2023. But despite serving the notice, QFS didn't in fact serve its referral until the 17th of May 2023, some months after the initial notice. Was that enough to keep the conclusive evidence provision at bay? Just remember, you have to get your adjudication on foot and not completed. So QFS won the adjudication. BPS brought a Part 8 claim, saying the adjudicator got it wrong because they said the final statement should have been conclusive. QFS brought Part 7 enforcement proceedings. Lucy Garrett, King's Counsel, appeared for Battersea, and Marion Smith, King's Counsel, led me for QFS. Alexander Nissen, King's Counsel, sat as a High Court judge. The issue was this. When did the adjudication conclude? Was it the lapse of the notice, or was it the decision itself? The University of Bright House against Dove House Interiors made it clear commencement is the notice, even if that notice lapses. But what happens if you serve a notice and then don't pursue it? At what point do you abandon proceedings? And this has been commented upon in an earlier case, Tracy Bennett against FMK Construction. And it comes down to an objective analysis. Now, QFS hadn't served its referral because it had erroneously but honestly concluded it didn't need to. There'd also been negotiations between the parties. It clearly hadn't abandoned the dispute. And indeed, QFS had always made it clear it intended to pursue the adjudication if a settlement wasn't reached. And as a result, it was held that QFS did not abandon the adjudication proceedings, and so the decision was enforced. So, when we get to the end of the adjudication, here's the moment we're waiting for: who gets to pay the fees for the adjudicator? And the point is this: if you subsequently overturn the adjudication decision by subsequent litigation or arbitration, but what do you do about the adjudicator's fees? And there's Scottish case law, which has been followed to a limited extent by English TCC. But an adjudicator's decision as to liability to pay fees is final. It's not subject to challenge in subsequent arbitration or litigation. And this was a point of law which was followed by Roger DeHar, King's Counsel, sitting as a judge of the High Court in A&V Building Solutions Limited against J&P Hopkins, where indeed the claimant had overturned the adjudicator's decisions in favour of the defendant, argued now that they should also be ordered to pay the fees and expenses of the adjudicator. And it was held by the TCC that the case law in England does support the case law that you find in Scotland. Although there are arguments suggesting that the Castle Inns case should be reconsidered, it wasn't pleaded. And I think it's important to note that you can try and argue, you try and plead these cases to get the fees back, possibly as damages. but no order therefore was made. It's quite different to the circumstances in which you try and get the money you've been ordered to pay over. You remember a case went to the Supreme Court about this. You can get this back either by an implied term in a contract or by way of a claim for an unjust enrichment. But this doesn't apply to adjudicators' fees. There's no contractual provision for it. One gets a feeling this is something the Court of Appeal may have to grapple with at some point if someone takes it any further. So, just going to wrap up the final few points that Jonathan Cope explored in the session in person about what can parties do to help an adjudicator. First of all, it's very tempting to be as aggressive as possible during an adjudication, and that's not helpful to the adjudicator, particularly when it comes to timetabling. Try and be collaborative. Secondly, ask for what you want, not only when it comes to the referral, but also when it comes to extensions of time, procedural directions, and so forth. Third point is this: get good advice. Adjudicators do not like having to deal with bad points, so parties should be well advised to get good advice. Fourthly, try and be clear in your statements of case. Try and summarize what you're going to say and give some proper explanation for it. Which always ties into the fifth point. More submissions is not necessarily better than shorter submissions. Of course, you have to make the point, but you don't need to be repetitious. You don't need to make the same point over and over again, which means I need to move on to number 6. Don't take bad points. It wastes an adjudicator's time to deal with the rubbish that sometimes gets put forward in adjudication. And then finally, but certainly by no means the least, the importance of evidence. Make sure you evidence your case in front of the adjudicator and make it clear what you're arguing and back it up with evidence the adjudicator can properly consider. That's it for me. I hope you have enjoyed today's session, and I'm going to hand back. Thank you very much.
David, thank you very much. And thanks also to Hannah and to Patrick. So I hope everyone's found that really useful. I think it's really great to get so many nuggets in 1 hour. Hopefully that sets you up for a nice week. We will be running our all-day construction conference again next October. Please come along if you can. Again, we try and pack in as many hot topics as possible in the day, so it really is a jam-packed, really informative programme that we put together for you. And indeed, if any of you've got any suggestions of particular topics you'd want talks on, please always let us know. So I think I'm going to bring that session to an end. We haven't had any questions, so hopefully, oh, hang on. Yeah, we've just had some nice thank yous on the Q&A. So thanks to everybody. Have a very good day. Goodbye.